Good afternoon, everyone. Thank you for joining us on this day 3 of the Just Culture conference. We are going to start right away. Just before I remind you, this presentation, those presentations are recorded and being streamed on YouTube. If you want to ask a question, please use the Q&A feature and keep them away from the chat. If you have any technical issues, yes, please communicate them by the chat. We'll try to help. I'd like also to remind you that the presentation and the link to the video will be published on Skybrary. Thanks a lot for your day, and over to you, Tony.
Thank you very much, David. Good day to everyone. A very warm welcome also from my side and my team at the third day of the Just Culture series of webinars. The webinars also on behalf of Roderick Van Dam, the Just Culture chairman, task force chairman. He could not make it today. So today we have another amazing line of speakers aligned for you. It'll be a very mixed day of academia, railway and aviation, again debating and discussing the principles of Just Culture. I will do just the introduction of the beginning, and then I will let you in the very capable hands of Federico. I wanted first, however, to start because it's a great pleasure for me to introduce the first speaker of the day. It's a good friend of mine, Professor Francesca Pellegrino. Francesca is a full professor of navigation law in Italy, and she's a prominent academic in the subject matter of air law. Among so many books, papers, articles, speeches, she wrote two fundamental books in the field of aviation. The first on the law of the aviation investigation from international, European and domestic perspective, with also an early focus on the issues about the relations between aviation investigation and judiciary ones. The second book has been issued just a few months ago. I got a copy here. Thank you, Francesca. So far, you know, when you are looking for books of Just Culture or just the book of Sydney, but now it's also Sydney Decker, now it's also the book of Professor Pellegrino. You know, it's on Just Culture as an outcome of several years of studies, research, and interaction with operators, such as Eurocontrol, to which she has promoted a long, fruitful partnership. So, and all these legal experts that we have and are the deputy program managers for the Just Culture program, like Federico, they are coming from the University of Messina. She served as a director of University Center for Transport Studies and for many years handling relevant researches in the field of aviation law. Federica, we are in your hands, please. Sorry, Francesca, I'm emotional.
I cannot see her. Probably, I don't know, maybe for technical reason. Tony, if we can start, I will.
With you, Federico. We are flexible.
Yes, I will take over just an overview, waiting for her because
okay.
He has another contemporary.
Then we do yours, and then we do Federico. So then we start with Federico.
Yes, perfect. So let me share the screen. Sorry. Perfect. So, oops. Well, just to give you some updates on the way that what on Just Culture Eurocontrol has done, the way forward and deliverables that we have done so far. The starting point is the Just Culture is, of course, to protect the reporter and also to take attention to this particular figure in the occurrence reporting incident. This because the Just Culture aims to balance two equal goals, enhancing safety from one side, but also the administration of justice. And so avoiding extremes such as immunities from prosecution and also misuse of prosecution judicial powers. This because the final goal is to protect the aviation investigation, the reporting, but also the normal course of the judiciary. To do so, Eurocontrol since 2012 has done so many activities. One of these activities, and we usually deliver it twice per year, is the prosecutor expert courses in which so far we have dozens of controllers, pilots, judiciary from Eurocontrol members, country members, but also, as you can see, from other countries outside Europe and Eurocontrol framework. The aim of this course is to put literally on the same table prosecutors, judges, controllers, and pilots in order to have their different view, their approach to incidents or accidents. And in our experience since the beginning, what we have seen so far is a very terrific improvement of the enthusiasm from judiciary and for controller and pilots, from aviation professionals to this subject matter. Together with prosecutor expert courses, also Eurocontrol basically arrange a national activity, a roadshow in single country between NSP and judiciary, and also until 2018 a strong collaboration and cooperation with the European Agency for Railways. In this sense, Eurocontrol and EURA has also hosted and organized the course not only for aviation but also for railway accidents and incidents too. And moreover, in 2019, alongside with normal and usual activity, also Eurocontrol has begun to experiment the implementation of just culture at corporate level with two important courses that we had in spring and in autumn, involving the CEO of several national service providers, and with the support of Christopher Hart that you have already met on the first day, based on the disaster of the Boeing 737 MAX, in which way we have seen how the just culture works at corporate level. Of course, the engine, as Tony already said, of this activity is the Just Culture Task Force, the chairman, Roderick Van Dam. The task force has very straightforward tasks to promote debate and discussion on the legal issues related to safety and justice, together with the support and dialogue between safety and judicial experts, but also, and we will see later on, to develop guidance material and policies in order to support the implementation and dissemination of just culture, and also proposals for consideration by relevant body. One of the outcome of this activity is the establishing of criteria for prosecutor expert list of Eurocontrol. The aim of this list is to create a body of experts able to support judiciary across Europe in case of course, aviation, judicial investigation on aviation incident or also accidents. To be part of this list, of course, the task force has laid down some criteria: experience, minimum 10 years of experience in the field, of course, of aviation, like controllers or pilots, independence from any union or management bodies, training, not only the normal one, but also the participation to prosecutor expert courses held in Eurocontrol or other Eurocontrol activities, together with knowledge and technical and communication skills. We think that by the end of this year or early next one, this list will be of experts will be published. And as we said, and as we will see also together on the fourth day of this webinar, the dissemination of just culture principle has embraced the other industries. Railways with a strong collaboration with the European Union Agency for Railways, but also energy, healthcare, and also maritime with several moments that several meetings that we had in consideration of the Costa Concordia case that still today is continuing to teach to everybody several aspects of the balancing about justice and safety. Another important stone of the Just Culture activity is the repository center. You can find the link in the library that is continuously updated. One of these last updates that we have done a couple of days ago was the Dutch prosecution instruction with regard to criminal investigation and prosecution of civil aviation occurrences. This was a very useful document that the task force has informally translated from the Dutch to the English, and you can access through the website that you find at the bottom of this slide. Or in any case, in this library, it's easy to find it. The outcome effects of this constant activity, of course, are cooperation agreements between Eurocontrol and other agencies and international organizations. Cooperation agreements also with national juridical school, but also, as I said, the implementation of Just Culture at corporate level. Another important accent is given to the relation between Just Culture and media. In an area of digitalization, which as we usually see, social media are able to disseminate information before official reports or official communication. It is also an important field in which Just Culture has to play a relevant role. Of course, the way forward is to developing and support Just Culture. And I think that as we have seen on day one with Andrea and Massimo, the judge's presentation, with yesterday from Nicola, but with also others' presentation, Steve, and so on, it is important to really create the Just Culture environment. And to do so, it is also important to support the national Just Culture model policy. In this sense, Eurocontrol has issued, together with European Agency for Railway, a model policy in 2000. The latest version has been issued in 2018, and it regards aviation and also railway incident and accidents. The policy is a very concise document aiming to address judiciary and in consideration of investigation on aviation or railway incident and accidents. It aims to make a coordination between safety investigators and judiciary authority based on the recognition about the necessity to protect reporting and not to be the reports used as an evidence. As deliverables, we have seen some of them. They understand the very excellent work about the understanding of biases of judgment for members of the judiciary. We had an example about it on Steve Shorrock's presentation. The Just Culture Manifesto launched by Tony the day one, but also the support and development of MOU across European countries between judiciary and NSP. In these years, we have seen a very important activity that Eurocontrol has supported that allowed to Luxembourg and Slovenia, for example, to reach this kind of MOU between NSP and judiciary. And I think that, for example, the position of Slovenia that reached at the early of this year, latest in 2019, this kind of MOU is a very paramount example on cooperation and support between experts, professionals, and judiciary one. But also, as a Eurocontrol, the implementation of the Just Culture at corporate level. In this sense, Eurocontrol is setting up the Just Culture Committee in order to evaluate the staff behaviors through the lens of the Just Culture, but also pay attention to an awareness campaign, training, but also ensuring the right legal protection and also the sanctions in the right terms. Of course, a relevant attention is also given to the coordination of the just culture with other aviation legal tools, the Paramount Regulation 1139 of 2008, and we are looking to the steps that right now, these days, European Union Commission and other bodies are doing. In this sense, it is also important take into consideration the acknowledgement of just culture principles that the proposal for single European sky has done is a proposal of September 2020, and the provision about the strong link between ATM, air navigation service, and human factor. And so the necessity to which member states should uphold the just culture principle. And this because the human dimension of the single European sky. Another important window is the review of the Regulation 376 2014 that is underway. So far, we, and as many of you know, the review is aiming to make an individuation of scheme about risk activities in the aviation useful for the reporting, and together with the other Regulation 996 of 2010. So far, we have the first step, the adoption of the delegated act by the European Commission. Other steps in the further weeks or months for such as the scrutiny by European Parliament, then publication and the official journal, and the entry in force and applicability probably by the end of this year or early next one. I would like to conclude with just to remember the chairman, Roderick Van Dam, is not here, but he usually say for just culture that is a very simple word, but it has a very deep and fundamental meaning because it aims to balance justice, safety, but also is an ethical issue. So that's why we call it culture, just culture. So thank you very much.
Thank you, Federico. Just inviting you again, if you have question and answer, to use the Q&A feature of the tool. Yeah. Use the chat just if you have issues with the connectivity. We went very fast through this series of deliverables that the Just Culture Task Force has created. I see why you may want to take this question from Cengiz. Even if you have consensus with the judiciary about just culture and how it is applied in criminal law, how we can provide legal protection for frontline operators against ambulance chasing lawyers?
Well, this is a very tricky question. I think that the Andrea Montagni judge presentation on the day one, but also yesterday Nicola Romano presentation about the environment. So the legal protection, of course, about frontline operators is a problem also, and I think that it is necessary to have a wider discussion about it, because at the same time there could be a conflict between the staff operator and also the organization to which him or her belongs. So it's not so easy to give and to ensure this kind of legal protection. And of course, it depends on the different aspects. So by this sense, the examination of the behavior through the lens of the just culture principle could help also in this case to allow a specific framework also for legal protection for operators.
Yes, thank you. Thank you, Federico. Let's not forget also that André Dujardin from ICAO in one of the last intervention of today will cover also the ICAO provision on the protection of accident incident investigation records and safety data, safety information, and related sources. I'm looking if Francesca is back.
No, I think
Francesca just disconnected, and she's, I think, trying to reconnect, but she's
okay.
disconnected.
I think, Tony, to go ahead.
Yeah, let's go ahead. Gregory, are you ready?
Say yes. May I introduce Gregory? Gregory is a safety culture expert within 15 years of experience in several safety critical industry. Because today he is a program manager and safety and operation unit at the European Union Agency for Railway, but he's also a consultant, a researcher at Mines Paris Tech. He participated in several safety culture and assessment also of nuclear plants and oil and gas facilities in Europe, Africa, and also North and Latin America. He's also a very excellent writer because his last book is on human and organizational factors in nuclear safety, 2013, if I'm right, in which Gregory underlined the importance of upholding a constructive dialogue between safety authorities and nuclear operators to stimulate the integration of human and organizational factors and enhance safety culture. So, Gregory, thank you very much. The floor is yours. Thank you.
Thank you very much, Federico. Are you hearing me well?
We can hear you well.
Perfect.
Thank you. So it's a pleasure to be here today. Yes, Federico, you offered me a transition when you mentioned the prosecutor expert training course. Because 3 years ago, when I joined the European Union Agency for Railways, attending such a course was one of my first activity. I would like to say that it was really a great surprise at this moment to see that our agency was cooperating with such a recognized expert institution, Eurocontrol, in this area of just culture, which we know how critical and important it is to improve the safety of our industries. I'm very happy to be here with you today to talk with you about the safety culture program that I'm leading, that I'm managing inside the agency with great colleagues. And more specifically, a model which is a theoretical foundation of our program, and that leads to several applications that I will briefly present. Few introduction about this agency, since most of you, I believe, are belong to the aviation sector. We are the equivalent of EASA for railways. And our missions have recently evolved with the implementation of what we call the fourth railway package, which is a new set of directives that started to be implemented in 2016, and which gave us a new role for granting safety certificates to the railway undertakings. The fourth railway package, while a safety management system has always been the cornerstone of safety for railways, introduced also safety culture. And this introduction into the legislation led the agency to launch an ambitious program in order to develop a positive safety culture across railways. So the model that I will present now is, again, the theoretical foundation of this program. So I will first give some background and specifies a little bit how we build the model together with our stakeholders. And then a first reading of the model will lead me to explain three building blocks of the model. Then I will mentioned the 24 attributes of a positive safety culture, which is a more detailed reading of the model. And then I will briefly mention two of the applications of this model, which is a safety climate survey we are going to launch next year, and an activities that we are already deploying, which is a safety leadership training. And I will end with some other developments also on just culture, since it's the topic of the workshops, and giving some remarks and maybe have some interactions with the audience through a Q&A session. So you know this very well. Safety culture is commonly accepted to be associated with unfortunate big events such as Chernobyl, Challenger, and in railway with the Clapham Junction accident. So on one hand, it has been developed emphasizing how much inappropriate behaviors at all levels contribute to these disastrous events. On the other, the concept also refers to features that shape group behaviors, recognizing cultural factors as safety dimensions. This acknowledgement is reflected by most of hundreds of definitions of safety culture, but really at the beginning of the development of the model, we were convinced that the definition was not sufficient to support the railway companies in order to work on safety culture and to improve their safety culture, which is why we started with the idea of building a model. So what we had about model was a very simple exception we took. So, and I use this definition of a model: to an observer B, A star is a model of an object A to the extent that B can use A star to answer questions that interest him about A. So that's really the basic definition we use for the model. And quickly, we set up some strong principle that a safety culture model for railways will have to fulfill. First one, that this model will have to be applied to any type of railway organization, whether it's an infrastructure manager, railway undertaking, entity in charge of maintenance, as we call it, or also investigators or railway authorities, whatever. A second one, we really wanted to distinguish, because based on the existing models on safety culture, we believed that they were mixing two different concepts. The first one on organizational culture and the other on safety. And we really wanted to distinguish this because, to quote Goldenmund, what relates to organizational culture is value free. You don't say a culture is good or bad. That's not the aim, but we know for safety what is good or bad. So here you clearly, safety is not the value free world. And one thing, the model has to be really useful for companies. However, it should not go to oversimplify the concept of culture. Culture is a matter of ethnographists. They spend months, lots of interactions with people in the field, with people in the organization, with managers, before daring qualifying an observations as a cultural observation or cultural phenomenon. So that's where the basic principle that guided us when elaborating the model. We also created a group. We were clearly convinced at the beginning when designing this model that we needed railway experts to help us designing the model, and also then after to promote the use of the model among the community. So we created this task force, and we met 3 times in 2018 to issue a first version of the model that we took really, after this first edition, we took really some time and some really experience to test the model, to challenge it against reality and real cases. And that's what we did. So in 2019, last year, so the model was used during workshops. So we did several workshops with different stakeholders in Italy, Greece, Spain, and the Netherlands. So the idea was really to build a common understanding of safety culture, and here the model proved to be really useful for the audience. More ambitiously, I would say the model would serve as a basis to conduct an assessment of a railway undertaking in Denmark. So it means that we did a survey based on the model, and then we did the interviews, observations, focus groups, and we were able to draw the safety culture picture of the organization using the model. Today, the safety culture model is used by the Spanish infrastructure manager to conduct a deep cultural change. So to design and implement a strategy to change toward a better safety culture. And they are so using the model to set up their assessment. They have just finished a big survey, and they will now carry out their focus groups. Also, the national safety authorities, the regulatory bodies are among our stakeholders, and the model has been used, for example, extensively by our Finnish colleagues to integrate safety culture in their regulatory oversight. So what is the model now that I'm going to present? The first building block, which is central, are the behavior patterns that encompass those shared ways of thinking and acting that characterize your organizational culture. I've selected two examples that can be designated as cultural, especially by an external observer. The first one shows a shared behavior that clearly goes behind the scope of the railway company. You can see all these people trespassing on the railway. The second one is famous Japanese pointing and calling here with a train driver. It also applies now to other railway professionals, and although firstly used in railways, it has been successfully exported to several hazardous industrial contexts in Japan. But two observations. While these two examples show visible and shared behaviors, they require further inquiry to explore the motivations and meanings. And second, if you are willing to say that one is good and the other is bad, I might agree with you. Although, have in mind that when you do this, you are already taking the safety lenses to observe and evaluate the organizational culture. And we will see in the next slide that the model allows and explains this shift. Second building block, the cultural enablers. So, and we use the Golden Moon for that. The cultural enablers describe the 4 steps through which organizational culture develop. Interacting. So here, interaction between peers, hierarchical interactions between contractors, etc., with authorities as well. Formalizing, and here an important part is played by the safety management system. Disseminating, communication and training are important manifestation of this dissemination step. And reinforcing, which clearly relates to leadership and safety leadership. So these 4 mechanisms, these 4 cultural enablers, are steps through which organizational cultures develop, and shared ways of acting and thinking are expressed. Now, the third building block of the model are the 4 railway safety fundamentals. And so after the blue part comes the green part with these 4 fundamental that we believe must be fulfilled by any organization to achieve sustainable and safe performance. So the first fundamental is about controlling major risks. So it's clearly knowing what are the major risks and make all staff aware of what they are. But it is also not to have a risk management strategy that relies only on anticipation, but also on resilience, and encouraging people to challenge assumptions and to have a questioning attitude. Second one, which is also very important, it's fundamental, understand workplace reality. And here, so it's really in the affiliation of the economics with the distinction of task and activity. It's acknowledging the importance of working conditions, understand and have an approach to safety which is recognizing the complexity of the system. And here I'm very also supportive with the Just Culture Manifesto released 2 days ago. I think the 5 bullets are really straightforward, and I know one of them is in relate with this attribute. And reporting also, and this is clearly linked with Just Culture as well. We want people to report any possible safety concerns, and we want them to be heard, and we want the systems to be improved when they report. So third fundamental is learn from experience. Once you have this reporting, you need to have an analysis, systematic analysis of these reports, and again, this needs to improve the system, and learning should be encouraged within the organization. The fourth one, integrate safety consistently. Safety is not only the business of safety professionals or the safety team of the company, it's integrating into all activities at the highest level through a safety vision, and it is reflected in the resource allocation and in decision making at all levels of the organization. So this is how we have the model now, with the blue part describing any organizational culture, and the green part that when fulfilled, this 4 fundamental, the organization can develop a safety culture which brings not only safety, but we believe also organizational excellence with profit and punctuality, for example, in the railway business. Second, reading, I said, and here I won't detail all of these attributes. I described the keywords for the 4th fundamentals, and I invite you to in our website, if you are curious about knowing more about these attributes. They are detailed and explained in the guidance that I will give the link at the end of the presentation. So we have 12 attributes here, and also 12 other attributes for the blue part, the enablers. And here you can see so 12 other attributes, and so together we have 24, a set of 24 safety culture attributes, which is a useful framework to carry out safety culture assessment. Now I will detail briefly some of the application, and the first one is the European Rail Safety Climate Survey that we are currently finalizing. So we will launch a really ambitious and big survey next year during the European Rail of Year of Rail, sorry, I'm reading my slide now, there is a typo. So it's a survey that will be open to any rail professional. So we have a set of safety questions that is linked to the model. And with that, we will be able to improve the safety of the European railways. So you see, it's impressive. It's we have potentially more than 2 million of staff. The survey will address both companies and authorities, And we are clearly now trying to establish tight partnerships with all stakeholders in order to have a high response rate. Of course, it's always a critical step for any exercise like this. It's really important. The quality of the questions is of first importance, but then if you don't have the replies, the exercise is jeopardized. So it's an important communication exercise. A second one is an important activity that focus more on the reinforcing part of the model, the force enabler, and also on the fundamental four, integrate safety consistently. We have developed safety leadership training, a one-day safety leadership training that target managers at all levels. We did a benchmarking for this and worked with one of our partners, the Institute for an Industrial Safety Culture, and also with Italian LIS. So it was originally a training, a similar training was implemented in Saipem, and it was a successful program that we wanted to propose to our stakeholders. So it's a one-day training that use several methods and really with an emotional engagement, and this is done through a film, a professional film, which relate an accident. So it's always this way that we work. We design with the support of stakeholders. We test it, and we tested it with Thalys and VR Group, a Finnish railway group. And now we have developed a train the trainer approach, and we are deploying this with Irish Rail and Hermeva, which is a wagon keeper in France. And here's an example of a session, a train the trainer session that we done in Valenciennes, where we are located. So a few more things to say. So this model, it's really at the foundation of the assessments that we are doing again, and that we are offering to our stakeholders. Adif, as I mentioned, is currently using the model for doing a cultural change strategy. We are also trying, I'm saying trying, it can sound a little soft. It's because of course with the current pandemic, it's difficult to imagine with the peer review service, but we are still designing a peer review pilot with some organization to really, and this is great learning from nuclear. I think this peer review arrangement works very well in nuclear, where nuclear power plant managers are really used to receiving people and reviewers to have a critical assessment done by external, and they are eager to learn. I would like to see this same eager to learn from the rail managers. So we are really willing to have this peer review service implemented across European railways. Regulatory oversight of safety culture, I mentioned already, the work we are doing with national safety authorities in order to help them to integrate safety culture. Survey and leadership, I mentioned, and just culture. So we have been working and cooperating, as mentioned by Federico, for a few years right now. And now my colleagues are currently designing, with the support of a task force again, a training in order to improve the implementation of just culture into railway organizations. Human and organizational factors is also an important topic for the team, and several types of trainings and toolkits are designed. So it's a little bit the different types of the projects that we are developing. So in a nutshell, to conclude, for us, the model is it's useful tools that we have elaborated and tested with safety experts and rail professionals. It articulates organizational culture with safety, address pragmatic needs, still respect the complexity of culture, and supports learning, cultural change, and improvement strategy. One event I'd like to mention, it's not in this slide as well. Another one, we have human and organizational factors seminar in the 2nd and 3rd of December. It's really on automation, so it's a topic for which the aviation sector is usually very interested. The link is not there, but don't hesitate to contact me if you want more information about this webinar, 2nd and 3rd of December. And we have we are willing to gather the European rail communities in Porto during the EU presidency of the Portuguese presidency of the EU. Where we will invite great speakers to share good practice in order to improve safety culture. Thank you for your attention, and I'm happy to try to answer some questions, if any.
Thank you, Gregory. I am seeing the question Q&A session, a lot of appreciation for you, for your presentation. Indeed, I have a request from Joe Bruggen about your slides because he lots appreciated the scheme blue and green. So I think you can say this is an evidence of cooperation between industries. Going to the question. The first one is about the change of safety culture. We have Robert De Boer that asked about an indication of time required from start of intervention to visible change in safety culture.
Yeah, that's a classic and tough question. It takes time. This we can clearly share this view. I think then there is also different parameters. So it depends on the type of organization, I would say. When you, for example, in railways, okay, so today you have small railway companies, but you also have very historical old companies, bureaucratic public state companies, and this is not a critique, this is some facts. So of course, cultural change within these organizations are, may take more time than a more flexible, light organization, if I say. So in the first type of organization, years, I would say 5 to 10 years at the minimum to change, while in a lighter organization, it could take maybe a couple of years to see some change, depending on the commitment of the main manager, I would say.
Okay, thank you so much. Another question from a controller, if I well remember, among the attributes, some nearly all major aspects of an accepted safety management system. Does the model include and progress an SMS professionally?
I think we tried really, and for example, if you take the enabler, the second enabler on formalizing, we try to complement what is currently known as requirements on safety management systems. And while of course roles and responsibility must be clearly defined, this is one of the feature of any good SMS. Here we really ask about roles and responsibility with more cultural lenses. They should be accepted and understood, which of course is, you see, it complements that it's not only a good definition, but it's how it is received by staff.
Yeah. This one about the safety climate survey is a question about how do you measure the success of the survey, and also if it is based on response percentage or the quality of data received by the participants.
Well, so here again, it's a tricky one. I mean, it's very common to have a response rate first. Yes, so if it's really low, then the company can be unsatisfied. I think, and the experts can be unsatisfied. It makes sense. Now, I would say also it's depending on the outcomes of the survey, what you do with the survey. For any safety culture assessment, myself, I'm convinced that a survey is is not the main data collection method. So you have to carry out interviews, focus groups to really understand what relates to culture in an organization. So the survey is just one step. It will be useful if it feeds more investigation inside the company.
Okay. We have the very last from Nicola Gallo, is an Italian controller. It's okay. It's about the fact that the aviation and the railway could create a very good environment for just culture, but is what we already said. Yes, of course. So thank you very much, Gregory, once again for your very excellent presentation. Now we have the Professor Francesca Pellegrino. I think she's ready. Professor? Okay. Okay. Good afternoon, Professor. So, Tony has already made your presentation. Remember us your books on aviation investigation law and the more recent one about just culture. Tony, if you want to add something, just or is okay. Perfect. So, Professor, please, the floor is yours. Thank you.
Thank you very much, dear Tony, dear Federico, and Professor Van Damme for inviting me to this very prestigious event, conference, co-organized by the University of Messina, KUST in particular. This is a great honor for us to cooperate for many years with the Eurocontrol. And I bring you greetings from the current director of the KUST, Professor Maria Piera Rizzo. And we hope that the next year conference will take place in Sicily at Messina University. First of all, I would like to respond to this question. What is the just culture? It's not a new concept. The first definition of this expression is contained in a very important technical document elaborated by Eurocontrol, Just Culture Guidance Material for Interfacing with the Judicial System. In this document, just culture is considered a culture in which frontline operators are not punished for actions, omissions, or decisions taken by them that are commensurate with their experience and training, but where gross negligence, willful violation, and destructive act are not tolerated. The European Union has been very receptive to the principle of just culture. In fact, another document, soft law document, entitled First Report on the Implementation of Single Sky Legislation of the same year, 2007, the European Union recommended the member states to apply risk management models to facilitate the uniform application of the just culture principle. Subsequently, regulation, the basic regulation number 216, that introduces common rules in the field of civil aviation, highlighted the great importance to exchange to allow circulation of information of accident and incident for safety. And at the same time highlights the need to ensure absolute confidentiality. But the first legal definition of just culture is contained in a regulation, a EU regulation number 691, relative to the air navigation services. This regulation transposed in European legal system the same definition elaborated by Eurocontrol. In fact, according to this definition, just culture is a culture in which frontline operators are not punished for action or missions commensurate with their training and experience, but it's a culture where gross negligence and willful misconduct are not tolerated. Therefore, this definition introduced a clear divided line between sample negligence and excusable mistake on the one hand, and willful misconduct and gross negligence on the other. At international level, the ICAO Assembly Resolution 837 introduced a similar definition. In fact, in this resolution, we find, we said in this resolution, ICAO said that disciplinary measures are not taken against operational personnel for their actions that are commensurate with their experience and training, but where gross negligence and willful violations are not tolerated. In addition, Annex 13 on safety investigation to establish a climate of trust and that allow voluntary reporting system to facilitate the collection of useful information for safety. Another regulation, very important regulation, must be mentioned. It's a regulation number 996 on accident incident investigation. This regulation does not contain a definition of just culture, and so want to recall the already mentioned definition, but is interesting to stress that the recital number 24 reiterates that the civil aviation system should promote a non-repressive environment, facilitating the spontaneous reporting of events and promoting the principle of just culture. In this regulation, is clear the divided line, the opposition between judicial inquiry and safety investigation. Judicial inquiry that aimed to satisfy justice needs, and safety investigation aimed to satisfy safety needs. In case of judicial inquiry, the purpose of judicial inquiry is to establish responsibilities, to assess fault. The purpose of technical investigation is to find out the causes of such accident. So in an investigation accident investigation, the goal is the approach is preventive. In a judicial inquiry, the approach is a repressive approach. Continuing this excursus with a specific reference to reporting system, regulation number 376 of 2014 reproduce the same definition of just culture already contained in Regulation 691. But develop it. In fact, in this regulation, Article 16 established that without prejudice to applicable national criminal law, EU member states are forced to refrain from instituting proceedings in respect of unpremeditated infringement of the law. According to this provision, malicious and severely culpable behavior are not protected. Article 16, paragraph 11, established that each organization established member states shall, after consulting its staff representative, adopt internal rules describing how just culture are guaranteed. So in the first case, in the paragraph 6, the attention is to the proceedings. In the second paragraph, 11, the attention is on internal introduction of just culture in organizations. At the national level, at the Italian level, the definition, common definition of just culture has been introduced in very important document, for example, in state safety program elaborated by ENAC in 2017. But the more recent legislative decree number 173 of 2017 that contain sanctions for violations of regulation 216 based on the principle of just culture seems to ignore this concept, establishing sanction without distinguishing between honest mistakes and willful or malicious or grossly negligent conduct. Another aspect should be underlined. The relationships between just culture and safety culture. According to James Reason opinion, just culture is one of the components of the safety culture. A culture aimed to enhance the safety needs. In fact, the principle, as well known, the principal goal of civil aviation is to ensure safe, efficient, secure, environmental sustainable condition at international, European, national level. In this context, safety is not considered according to the common meaning as freedom from danger or risk, but is considered as a situation in which risks are reduced and controlled to an acceptable level. In the light of the above, there is a coincidence between safety culture and just culture, because safety culture is a learning culture, is a proactive tool to anticipate accident by creating an atmosphere of confidence that allow the identification of information for useful for safety. On the contrary, just culture is in contrast with blame culture. Blame culture intended as the culture in which individuals must be blamed for mistakes in any case, for all errors, in any case. So in this context, is very interesting to refer to an example of blame culture. That is the case law of the Italian Supreme Court on the disaster of Monte dei Sette Fratelli. Disaster occurred near Cagliari. And in this case, the Italian Supreme Court judgment of 2010 has sentenced the two air traffic controllers of the Air Force for giving a night visual approach clearance without providing the pilot all the necessary information about the orography of the terrain. During this very important process, technical experts appointed by the judicial authority concluded that the main cause of the disaster was the decision of the pilot to execute a visual approach. But, however, the Supreme Court wondered how the pilot was allowed to descend at that low altitude without any intervention of the controllers. Despite the conclusions of judicial experts who testified that the two controllers had followed technical rules, regulation, procedures in force. The court established that the controllers were also required to comply with additional requirements. And so the behavior of the two controllers was found by the court negligent, imprudent, and unskillful. And in addition, non-compliant with the rule governing visual approach. Article 43 that distinguished between general negligence and specific negligence has been applied in this case. The controllers have been considered police officers. This function imply a safety position, a position of guarantee, that requires a very high level of diligence. By contrast, a just culture aims to create an atmosphere where people feel free to report without the risk of being prosecuted, without the media conditioning and pressure. However, it should be noted that although a just culture promotes a non-punitive climate and atmosphere, it is not a system of total impunity. In fact, gross negligence and willful misconduct are not tolerated. In conclusion, Most of Europe's legal system, including Italy's, are still influenced by a widespread blame culture. This highlights the difficulty to reconcile international safety principles and national criminal law, especially from an interpretative point of view. The EU and the international common definition of just culture is based on the clear divided line between intentional and unintentional behavior. But the problem...
Federico, I think we lost... Go ahead, Francesca. For a while you're frozen. Yeah, go ahead.
Okay. But the problem is that it does not clarify the concept of gross negligence. Indeed, the original proposal of regulation number 376 tried to introduce a definition of gross negligence as any manifest and deliberate violation of the duty of care that cause foreseeable damage to people or property and reduce the level of aviation safety. But this definition has been deleted by the final text because the agreement on it has not reached by the member states. Despite this shortcoming, it can be assumed that this concept of gross negligence refers to a degree of serious disregard to an obvious risk and failure to take the reasonable care. But a clear, agreed legal definition would be desirable to avoid difficulties of interpretation. The best way to break down the barriers to implementing a just culture into national legal system and so to reconcile the conflict interest, safety and justice, safety and accountability, is to adopt and implement national aviation prosecution and organization policies that are inspired to the European principle. I think that an improved dialogue between the judiciary and specialist professionals, such as this annual conference, is the only way to make progress in the field of just culture. Thank you very much for attention.
Thank you, Professor, and thank you for your brilliant presentation. I think that your experience, your research should be deeper evaluated by, for example, Italian legislator due to the fact that we are in Italy. Italy is a country that suffered and dealt with three fundamental disaster and incidents in aviation. I refer to Linate, also to Cagliari, but in the case of Linate. Maritime, we had the Costa Concordia case, and also railway, we have the Viareggio case accident too. So I think that Italy, I don't know, but probably could be a country that among other countries in Europe could implement a very strong legislation on just culture based on these three different facts that happened in three different industries. So I think we are perfectly on time for the virtual coffee break. So please stay connected. We will be back at 3:30 with the other session. So thank you very much.
Thank you.
So David?
I'm going to put the music and share the screen. So I'll be in just a second.
Thank you.
Good morning, everyone. We're back online.
So welcome back. We are in the second part of this day 3 webinar, and continuing to explore the just culture from an organization point of view. So it's the turn of the English, the UK railway system. We have Paul Appleton, who is Deputy Director, Railway Safety and Deputy Chief Inspector of Railway for UK, Office of Rail and Road. Paul leads all of the railway inspector that regulate all of the operational rail network within Great Britain. They are responsible for ensuring legal compliance, safety certification, and safety authorization and continuous improvement of safety for infrastructure and training operating across the network. Also, Paul he has a background in agriculture and strongly supports his choice of lies. And I want to be, if you have a place in your farm, please give me a notice. I will take the first train. Okay, Paul, thank you very much. So the floor is yours.
Thank you very much. Let me get my screen up and running. So let's click buttons. Wonderful. So today I'd like to talk to you about the way we make decisions around formal enforcement. I suppose the one thing to start with is that the UK's method of jurisdiction is very different to the way most of Europe's legal systems work. The flexibility in our law is built into our legislation rather than given to the judges. Basically, the judges have no choice. If the law says X, X is the answer. There is no choice. We don't have investigating magistrates or judges or anything like that. Just they don't exist in the UK. So instead, the legislation has to be flexible and to cope. And if you were in the UK, we would talk a lot about what is judgment. So we use words like so far as is reasonably practicable, a method of weighing. But that also means that when you come to making a decision about whether or not you're going to take enforcement action, then you need to be very clear, because it is the prosecutor, and we are the prosecutor, that needs to do it. So let's tell you a little bit about hang on, get the right button, there we go. So let's tell you a little bit about the Office of Rail and Road. So we are a combined health, safety and economic regulator. We also have a monitoring role over our strategic road network. That's primarily financial, economic function. It's driven by a combination of both UK and EU legislation. And of course, the UK is also broken into 4 different governments, and we're also accountable for legislation passed by those subsidiary parliaments, e.g. the Scottish Government. And we are accountable to Parliament, so we would end up being taken into Parliament to sit in a committee if they felt we weren't doing our job properly. Our role, the part of the system that I look after is about protecting the people who work on, use or interact with the railway. And that's to ensure the continuous improvement in health and safety. The greyed out areas you can see on the slide describe what the rest of my office do. So there's an economic bit. So this is about making sure the money is spent well and to temper the power of our infrastructure manager, Network Rail. and also to ensure fair access and so on and so forth. I'm not going to spend any more time on that. So what am I going to cover? So I'm going to talk a little bit about our enforcement policy statement, our enforcement management model, and to give you an example of how we actually go about making decisions around enforcement. If you want to read any of these, our website, these documents are all available on our website. You just go to or.gov.uk and type in enforcement policy statement or enforcement management model, and it will show you links to them. What am I not going to do? So I'm not going to talk about the selection of incidents for investigation. I'm not going to describe how we carry out our formal investigations, how we go through an approval process. So we are unusual body in that I don't have to go to another body to actually get approval of a case to go to court. For almost all other criminal legislation in the UK, you would have to go to the Crown Prosecution Service and get them to actually take the case forward, but we don't. We can do it ourselves. And we also conduct our own cases in court. The lower courts, I and my inspectors have a right of audience at the low courts, but for the vast majority of the cases we take, we actually use lawyers to do that work for us instead, and we have our own in-house legal team that partly do it. So who are we? So we have 80 inspectors and inspector assistants who actually do the enforcement of the legislation. We cover all of the mainline railway. We do light railways, the London Underground. We do metro railways. We do all the tourist railways. We've got 220 heritage railways. We also do tram systems. We've got 8 tram systems, and then there are a few other guided railway systems that we cover as well. And we cover the health and safety both for the travelling public and for the workforce. So we do workforce safety as well as public safety. Now, what is slightly odd is that actually the power to take enforcement is the inspectors. It's not the Office of Rail and Road. It's the inspector. So it is the inspector who has to sign the summons to get people to come to court and answer the charge that has been laid by the inspector. So as you would imagine, we have some very tight controls around the competence of our people and also the management of our people. So there are lots of checks and balances around how do we actually do that. So health and safety legislation in the UK is criminal law, but actually the vast majority of what we do is give guidance, verbally, emails, letters, and that's 99% of what we do. So to give you some example, we have a variety of different legal tools we can use to enforce the law. So we have a tool called an immediate prohibition notice. So this is we only use them very rarely, and it's when an inspector turns up on a site and finds something that is immediately dangerous. They tend to be almost always workforce safety issues, and you just want them to stop right then, immediately. And that's all you can do with it. It just says stop. A far more powerful tool is actually an improvement notice, and I'll describe a bit more about one we served later as my example. And that says, we think you've broken, or I think you have broken that piece of legislation. Here's why I think you've broken that piece of legislation. And by this particular date, you must do X, Y, and Z. And actually go forward and do that. To give you an idea of numbers, prohibition notices, we served 4 last year. but we've served 20 improvement notices last year. Prosecution. We also prosecute people. At the higher courts, the fines are unlimited, and there is the option for prison for individuals. Again, it's rare. We took 3 prosecutions last year and 4 in the previous year. I'll tell you a little more about Renown in a minute. But we do take, whilst we do take enforcement action against individuals, train drivers and signallers and control room staff and all sorts of people, it's actually rare. I can think of 2 in the last 10 years, but actually we prosecute companies for their failure to deliver a safe system on a far more frequent basis, 3 or 4 per year. So these were the prosecutions we took last year. And my year, to give you an idea, runs from April to April. So last year we prosecuted Govir Thameslink, who are our largest train operator, and it involved failure to do a risk assessment relating to an opening window on a train, and a member of the public put their head out of the window and died when they hit a signal gantry. The next one relates to DB Cargo, so that's Deutsche Bahn. So we have a German company operating freight. It's our largest freight company in the UK, and we prosecuted them following trespass of children onto their site, and one of them received a 25,000 volt electric shock. As you can see, the fines for both of those were very significant. One's 1.1 million and DB Cargo's 1.2 million pounds. These are very large companies with very, very high turnovers, up in the hundreds, if not billions of pounds per year. The last one was a much smaller company, Renown Consultants. Their job is to weld the railway together. But on this particular occasion, 2 men died in a road traffic accident. And you think, well, what's that got to do with the railway? Well, these welders had been working, one had been working for 24 hours straight at the request of Renown, and they were driving home, or they were driving from site to their depot, and died on the way home. And on that basis, we said that they were fatigued. That is an offence. We had a long trial at our senior courts, and they were found guilty and fined. So, health and safety compliance and enforcement policy statement. So, our job is to enforce the law and ensure the railway industry delivers continuous improvement in health and safety to passengers, the workforce and the public by achieving excellence in health and safety culture, management and risk control. We believe in firm but fair enforcement of the legislation. And the law sets out the regulatory principles that we must follow, and it has to be transparent, accountable, proportionate and consistent, and well targeted. So, key principles: target enforcement on those activities that give rise to the most serious risks. It's proportionate to the level of harm. So you'll notice in the cases I've just detailed for you, they all involved a fatal accident of some description or other. They have to be consistent. So that means we need to really think about the consistency and being similar all the way through. We need to be transparent. So not only the duty holders, i.e. the companies we're taking action against, but everybody else within the industry understands what's expected of them and what they should expect from ORR. And we're also accountable to the public for its actions. And we have mechanisms to respond to complaints. So if necessary, I could be required to give an explanation of my actions, and the office as a whole could too. And ultimately, our Parliament can and does haul us in to be questioned. Luckily, it's not usually me, it's my boss, but there we go. If he's off sick one day, it might happen to me. I hope not. So we move to enforcement management model. So this tool is used by a number of organizations across the UK, and it's there to help us make good decisions. So it isn't actually our tool, it's actually published by the Health and Safety Executive. And there's a link at the bottom of this particular slide to show you where you can go and find it if you want to read all of the details behind it. But it's around helping individual inspectors make judgments, because we found that whilst experienced inspectors and people who've done the job for a long time and well trained and all the rest of it were pretty good at making consistent judgments and could explain why they did what they did, we weren't very good at recording the why and the how and all the other thinking behind that decision making. So this tool is mainly around helping experienced people write down their decision making, and inexperienced people talk them through the process. So quite often we'll use it as a training aid for our inspectors. So we actually understand, they understand what they've got to do and how they've got to do it. And it's about making sure that that enforcement is proportional to the health and safety risks and seriousness. And it helps managers, and I suppose I sit at the top of that tree. I've got 4 senior inspectors that report to me, and they've got 18 principal inspectors who manage various teams of people all the way across. But it helps them making sure that there is that fairness and consistency in inspectors' enforcement decisions. And it also helps less experienced people make those decisions as well. And actually it helps with the transparency acts as well. It helps others who are directly affected and members of the public sometimes to understand the principles that the inspector has followed when deciding on a particular course of action. And that can be very useful. If you've got a member of the public who is quite often jumping up and down and going, I want you to prosecute, I want you to prosecute. And it can be useful sometimes to use this tool to actually explain why you've decided that, no, this isn't a good idea, this isn't consistent, it isn't fair, it's not in proportion with everything else. They may feel very slighted, but I've got to try and achieve a balance across the whole of the country. So this is a flowchart from the document that was linked to it earlier up. If you want to go and pull it off and go through it, you can. And it just gives you an idea of the steps we're going to talk through. Now, I'm only actually going to talk through the health and safety risks one, but you can apply this to permissioning regime. You can apply it to administrative arrangements and so on. But and then we'll just go through the priorities for action. Then the first thing is there a risk of serious personal injury? So is there a big problem you really need to deal with right now? If there is, go away and deal with those first before you worry about anything else. So do you need to serve that prohibition notice? Do you need to stop the job? Don't worry about the paperwork, go and make things safe. And then we work our way through the risk gap, initial enforcement expectation, duty holder factors, strategic factors, and then a conclusion. So what are we talking about? Step 1, what's the issue? First thing to do is to write down what the issue is. What's the actual problem that you've got in front of you? And the first thing on the form it says is write it down. Step 2 is around this dealing with serious personal injury. And if there isn't an immediate action you need to take, then get back and worry about further enforcement. a long time ago, before I dealt with railways, I dealt with construction sites and so on. And I remember turning up to the site of an explosion on a construction site, on a demolition. And everybody stood there looking at the result of this explosion. And my first question was, is the place still safe? And at which point they all looked at me and went, we don't know. So we had to go and deal with that before we worried about the investigation or did anything else or the site. Let's make sure the site is safe. And then the next step is to determine the risk gap between, and what we've got here is what the benchmark risk is, and I'll talk about a bit more about that in a minute. So if you did it properly, where are you? And the actual risk, which is where are you actually? So what's the difference between actual risk and benchmark risk? So actual risk is determined by doing an inspection or an investigation. And what you've got to try and find out is, what's the consequence? What's the nature of the harm that either could occur or has actually occurred? So if you have a fatal accident, it's very obvious you have a dead person. But sometimes, of course, we get there before it's actually realized. But you look at it and you think, this could kill somebody. And you need to worry about that. And then you need to think about likelihood. How likely is this actually going to happen? And sometimes you can rely on industry data. We've got lots of accident data and so on that tells you about likelihood, but also it can come down to experience. And the last one is extent. How many people could it affect? So is this going to be one person who gets knocked over on a level crossing? Or is this a multiple fatal accident because the train is derailed and gone off the side of an embankment, as happened in Scotland in August, and we had the driver, the guard, and one passenger killed. We only didn't have any more people because of COVID, and the train only had 9 people in total on it. So you had a 1 in 3 chance of dying if you were involved in that accident, which aren't very good odds. And then we move on to benchmark risk. So this is where standards and guidance that describe how the risk should be controlled is really important. So for the industry, as I'm sure there is exactly the same in the airline industry, there's lots of paperwork that will tell you how you should deal with each and every risk out there. And that is a really powerful tool. Now, here it's a pretty simple thing. So the one along the bottom is benchmark. So the vast majority of benchmark risk is going to be, if you do everything right, you should be in the bottom right-hand corner. So it will be a minor injury with almost no likelihood of it actually happening if you've got it right. But then on the left-hand side, we've got what actually happened. So if you've got a serious personal injury and somebody's died and it's actually happened and it's come to pass, then you're red. So therefore your risk gap is classed as extreme. And you can rerun this for it. It can be quite useful that if you've got a fatal accident, this is actually quite easy to do. It's much more interesting to do this with examples where you haven't, nothing's actually happened yet, and then this tool comes into its own much more, enables you to think a bit more about where it's going. But it's a useful exercise. Standards. So this is around trying to decide what the quality is of the documentation you're talking about. Is it defined standard? Is it the law? Is it an approved code of practice and so on? Or is it an established standard, CENELEC, TSI, or something like that? And an interpretive standard would be something that's come up by the industry as a whole. And it tries to give you an idea of the quality of the standard and how you should apply those. So you need to take that risk gap and the authority of the relevant standard to determine that initial enforcement expectation. We've talked about the standards bit already. So if we start at the top left, risk gap is extreme, and you've got a piece of legislation that says you've got to do this, then the initial expectation is improvement notice. Oh, and you've got to prosecute as well. And as you move down the risk gap and so on, then the different legal tools that come to play come out. And you'll notice that letters, inspections, verbal warnings, and all the rest of it do play a part in enforcement. We do class them as enforcement as well as prosecuting somebody. When you end up with something, you end up with the duty holder factors. So have you written to them about this topic before? Has there been an incident like this before? Has somebody taken an economic advantage? So are they saving money by not doing something? How badly was somebody hurt? What is the general site like? Inspection history, attitude. Do they care? Do they generally care? Or are they trying to get rid of you and don't really want anything to do with you? I've dealt with both sides of the house on that one. Strategic factors are much wider issues. So what's the public interest? Are we talking about vulnerable groups? So if we talk about children, disabled people, those sorts of things. What's the long-term impact? If you can, with one piece of enforcement, have a long-term impact, then you should maybe think about doing it. What effect is it going to have on the duty holder? Will it actually achieve compliance? An impact. Oh, finally, did we meet our policy? And then lastly, you need to actually write it all down, do a summary. Does it deal with those risks? Have you dealt with the cause of the risk? Have you managed the immediate failures? Are the underlying issues addressed? Are you going to get sustained compliance? And have you got the evidence to support the action? And have you got the enforcement policy statement met? Have you met the policy statement? So I'm going to take you quickly through a practical application of EMM to formal enforcement. Excuse me, wet my throat. So over the recent years, we've had a number of track worker fatal accidents and near misses. So this is where track workers have been hit by trains. The infrastructure manager for the UK, Network Rail, has tried several times to change worker behaviour, but it hasn't been very successful. And we were seeing this long history of incidents. So we carried out a series of inspections across the whole country using several teams of people to look at track worker safety, to gather evidence to support formal enforcement, and to demonstrate that it wasn't just in one local area, it was across the country where we were from. And one of the key issues we found was that Network Rail relies far too heavily on an unassisted lookout. So this is literally a man with a flag and a horn stood at the side of the track, looking up the track, waiting for a train to come in. Train comes, waves flag, blows horn, hopefully catches the attention of the people who are actually doing the work. Sometimes they do, sometimes they don't. So this is the enforcement assessment record for this particular case. So inspection findings from 1819 demonstrate the Network Rail's arrangements for ensuring the safety of persons on or near the track rely too heavily on unassisted lookout protection without looking for consideration of risk controls further up the risk control hierarchy, such as doing the work when trains are not running or using technological means of warning or protection. And we found inconsistent improvement plans. So we thought about an immediate prohibition notice, but that would have stopped every train in the country, which would have been difficult, shall we say. So instead, we move a bit further down. So actual risk, consequence serious, it's going to kill people. Likelihood probable. We'd already had one person killed at the time this was being thought about. And subsequently, we've had 3 more. And then benchmark, the consequence will still be serious, but if you did it properly, the likelihood of it happening would be nil or negligible. And if you go and look at the pretty colored table I showed you earlier, it shows that the risk gap is extreme. Now, the benchmark standard here is around this Act of Parliament, talks about protecting the workforce. So there is a defined standard. And if you go and look at our initial enforcement expectation, it talks about prosecution and improvement notice. Now, prosecution we're still thinking about at the moment, but we did go with the immediate, with an improvement notice. Is there a record of so this is talking about the duty holder factors. So is there a previous record of previous written enforcement? Yes, we'd certainly spent many years talking to them about their problems. Have we got a history? Yes. Have we spoken to them about it previously? Yes. Did the duty holder gain economic advantage? No, they didn't. Actual harm, serious injury, standard of general conditions. Well, around the place, they're pretty good, actually. They're reasonable to good. And ditto, their inspection history is also reasonable. Our Network Rail are actually a pretty good employer overall, and their attitude is very positive, actually. No problem saying that at all. And we have some confidence they will comply. The only reason we're not completely confident is actually because it's so difficult to do it. Because basically they've got to shift the culture of everybody that works on and around the track, and that's around about 60,000 people. They seem to like going on and around the track with a lookout, a man with a flag, rather than doing other things, mainly because it's quick and it's easy to set up, whereas the other methods are not so easy. And the part of what we're trying to do to persuade Network Rail to do is actually make the better control systems easy. So does the indicated action comply with the public interest? Yes, we're not going to kill people. Are vulnerable groups protected? Well, no, because there are no vulnerable groups affected by this. You're not allowed on the track if you are vulnerable, especially in terms of in medical and eyesight and all the rest of it. Will it result in sustained compliance? Well, we hope so, but we're not certain, which is the reason why it's gone no. And then will the action result in the benchmark being achieved? Again, this is really quite a difficult one. We can't be certain that it will, because this is certainly not the first time we've tried to shift the culture, but this is a really, really big task. This is definitely like trying to steer a super tanker, because you're trying to shift the way people think and behave across the entire organization of Network Rail, tens of thousands of people, and the way they do things. It is acceptable. And so far, we're still working on the enforcement policy element of this as this separate to this particular piece of work. Enforcement action plan. So at this stage, the inspector, Tom, was thinking about what do I do? Do I serve a deferred prohibition notice or do I serve improvement notices? Now, the reality is what he actually did was serve two notices. One relates to planning, so that Network Rail has to put in a new planning system to ensure that when people go out to work on the track, they actually have a plan to go and do it safely. They plan to do it when the trains aren't running. And then if they have to go out whilst the trains are running, then are there some technological systems they can put in place to provide a more reliable protection than the man with the flag? If you want to go and look up lots of the details and things here, you can. I suppose the one thing I should close with is these particular notices are still open. They will run until 2022, because as I said, the cultural aspects that are being required to shift are such long term. We think it's going to take that long to actually get Network Rail to change its what it wants to do and how it wants to do it. So if you've got any questions, I'm more than happy to take them now. My email address is on the screen, and please email me if you want to ask me more questions outside of this environment. So, Federico.
Thank you, Paul. Very interesting presentation. We have just a remark from Suzette Woodward about the necessity to talk more about the majority of events, incidents that happen every day, and what the appropriate response should be. As you already mentioned in the prosecution and also safety from safety point of view. But this is a comment from Suzette. I think that you will receive more questions directly to your email address. So we are perfectly on time. So the last panelist and continuing and completing the voyage from in the organization world. So it's the turn of Arnaud Desjardins from ICAO. Arnaud is the regional officer and safety officer at ICAO, at European and North Atlantic office in Paris. He has a university degree in engineering, in aeronautical engineering, 25 years of work experience, including 16 state civil aviation authority, and also 6 in the private sector in the United States, developing ATC system for FAA. He also worked as a safety investigator for the French Safety Investigation Authority in Paris during 12 years. And he also joined to the ICAO 3 years ago. So please, Arnaud, the floor is yours. Thank you. Many thanks again.
Thank you, Federico. Thank you for inviting me to this conference. So I will start by saying that I am not a lawyer. I'm certainly not a judge, not any kind of legal specialist, but nobody is perfect. But no, the objective of this presentation is to provide a description of the available international provisions to be used when there is a question about the protection of safety data, safety information, or investigation record. And let me share my presentation. You should be able to see my slides now. There are different types of protection, and this is depending of what to protect, how do you want to protect it, and why is there a reason to protect or not the safety data, safety information, or investigation records. So first cases is, let's talk about accidents, and this is contained into in Annex 13 to the Convention of International Civil Aviation, accident, aircraft accident and incident investigation. I will not, of course, provide a whole description of Annex 13, that would be too long. However, I do want to dwell on a few of the provisions, and to one of the most important one is at the beginning of Annex 13. And it says that the sole objective of the investigation of an accident or incident shall be the prevention of accidents or incidents. And it's not the purpose of this activity to apportion blame or liability. So how do you do to not apportion blame or liability? Annex 13 contains provisions in 3.2 related to the independence of investigation in Annex 13. 3.2 says that the state shall establish an accident investigation authority that is independent from state aviation authorities and other entities that could interfere with the conduct or objectivity of an investigation. So there are two reasons why independence is important. One, independence means credibility. So because an accident investigation authority needs to be separate from the oversight authorities which issue or to amend and revoke licenses, certificate, and approval. The accident investigation authority needs to also be separate from authorities responsible for rulemaking, and accident investigation authority needs to be separate from industry to avoid any kind of perceived or actual conflict of interest. As you know, one of the main product of accident investigation in the report, in the final report, are safety recommendations. And safety recommendations are just that, recommendations, and therefore are not compulsory. All these items build the credibility of investigation, and therefore the strength of its message to possibly change anything in regulation, in procedures, and so on. Second main reason is of independence is to assure the continued availability of investigation records, disciplinary, civil, administrative, or criminal proceeding against operational personnel or organization may inhibit the future availability of such records. So to further talk about criminal proceedings and how to find the right balance between accident investigation in Annex 13 and the administration of justice, Annex 13 also contains provisions 5.4.1 saying that any investigation conducted in accordance with the provision of this annex, so basically, let's remember accidents, when it involves accidents, shall be separate from any judicial or administrative proceedings to apportion blame or liability. And also a recommendation in 544 saying that a state...
Arnaud, sorry to interrupt. David speaking. The sound of your mic is not always on. Could you even try to switch to the mic on your camera or to the mic on your headsets?
Okay, I'll try that.
If you select a different mic from the sources.
Okay, is this any better?
Much better, thanks a lot.
Okay, sorry about this. So I was talking about the independence of investigation in Annex 13, and recommendation 544 said that the state should ensure cooperation between the Accident Investigation Authority and the judicial authorities, so that an investigation is not impeded by administrative or judicial investigation proceeding. And this cooperation may be achieved through pre-arranged agreements or other agreements between the investigation authority and the judicial authority. On that matter, I would like to draw your attention on the ICAO website. Some states have chosen to share their protocols or agreements with other states. So this is made publicly available, and you can download as an example for your state or for your knowledge what, for instance, has France done in terms of a protocol with the Ministry of Justice and the Accident Investigation Authority. We also have the example of Romania on the screen. So you have the link. I encourage you to visit this website to have examples of agreements between justice and accident investigation authorities. On that note, you may be aware that ICAO also conducts audits to ensure safety oversight and accident investigation capabilities of states. And one of the questions of those audits talks about the cooperation between the Accident Investigation Authority and the Judicial Authority, and has a protocol been established in that state. So I just wanted to share with you the results of the world globally today. So a little bit more than 42% of states have been found during audits to have an existing protocol between the Accident Investigation Authority and the Judicial Authority. So what to protect? Again, Annex 13 in paragraph 5.12. So it includes information related to an accident or incident. It includes the records that need to be protected. And the disclosure or use of such information for purpose where the disclosure or use is not necessary in the interest of safety may mean in the future that this information will no longer be openly disclosed to investigators, and therefore could affect seriously aviation safety. So 5.12 lists which records need to be protected. So I would just like to draw your attention to the word protection that is now introduced in Annex 13. Please be informed that up to 2016, Annex 13 for that paragraph was talking about non-disclosure of investigation records. And it has been now changed protection, introducing the idea that it was not reasonable to hope for a total non-disclosure of investigation record. On the contrary, there is a balance, and there is a balance to find between the enhancement of safety and the proper administration of justice. So these records, of course, contain, in particular, the cockpit voice recordings, also the airborne image recordings, and also any kind of recording and also statements obtained during the accident investigation. To further detail the way the protection is done for accidents in Annex 13, I would like to refer to you to its appendix number 2. and also to ICAO document 10053. This is the manual on the protection of safety information. And that those texts introduced the notion of a balancing test, which is not aimed to prevent the administration of justice, but I was saying earlier, have to find the right balance. That's why it's called balancing test. Also to prevent privacy violations of person involved and ensures moral dignity, and also ensures the availability of essential information. And in accordance with 5.12 that we saw earlier, each state shall designate a competent authority who will will have the task to administer this balancing test. And each state shall designate a competent authority to do that balancing test. So in some states, it could be the judicial authority itself. In some other states, it could be another higher or totally other authority. Still, about Annex 13, in appendix number 2, it says that during the work of that competent authority, that competent authority should record the reason for its determination, one way or the other, when administrating the balancing test. And the results should be made available and referred to as necessary for subsequent decisions. And those decisions may be submitted to ICAO and then, of course, made publicly available if this is the decision or the choice of the state to make them publicly available. Again, I invite you to go to the ICAO AIG or Accident Investigation section website, and you will have examples of past decisions where there was a balancing test to be made between releasing accident or incident records or protecting it from any other use other than safety. On that note also, there was an interesting study or consultation done in the European Union regarding the EU regulation pertaining to accident investigation, and that's EU 996/2010. And in particular, it's Article 14.3. And the question was to all the member states, which authority in your state is deciding on disclosure of records? It is interesting to see on this graph that for some of the member states, this is the Safety Investigation Authority itself doing that decision to disclosure records or not. In some other states, this is the job of the justice, whether they breach 996 or not. And in some other states, this is a third party, in addition to court. It's also interesting to see that for some of the EU member states, there is, at least in 2014, no such authority currently designated to do this, this decision on disclosing records. So as you may know, or you know also, Annex 13 requires that final reports are made publicly available in the interest of accident prevention. And the final report is not subject to the protection under the paragraph we saw earlier, 5.12. However, the use of portion of the final report, in particular the analysis, the conclusion, and the safety recommendations as evidence before national courts in view of assigning blame or liability is against the purposes for which the investigation was undertaken, as we saw on the first slide. And then in order to limit the use of the final report for purposes other than the prevention of accidents, states should consider differentiating between the part of the final report in order to use only the factual information contained in that final report, and while preventing the use of analysis, conclusion, and safety recommendation for apportioning blame or liability. Again, I invite you to go to IQO website to see some of the available final reports that are publicly available and free for download. So now that we have talked about Annex 13 and the set of protections for mainly accidents, when accidents, and so a serious, when there is of course, serious injury or substantial damage to aircraft, and of course fatalities. We deal with Annex 13 set of protections and rules. Now, if we talk about incidents or events or reports, this is where we can now talk about Annex 19 safety management. So in Annex 19, it says that, okay, states shall establish and maintain a state safety program, you know that. Also, states shall require that service providers implement an SMS, you know that too. And in that context, states shall record protection to safety data captured by and safety information derived from voluntary safety reports. We talked, I think one of the previous speakers talked about this, voluntary safety reporting systems in accordance to Appendix 3, and also the same, but it's a recommendation for mandatory mandatory safety reporting system. So it was said several times during this conference seminar, a reporting environment where employees and operational personnel may trust that their actions or omission to act that are commensurate with their training and experience will not be punished is fundamental to safety reporting, to preserve safety reporting. Otherwise, it's what I call the vicious circle. If there is an increase of actions against pilots, you will have less reporting and therefore less information. You will therefore have a decrease of investigations and lessons learned drawn from the events being reported, and therefore decrease of aviation safety, and therefore more incidents, even maybe accidents, and then you have more pilots to take action against. So voilà, this is the vicious circle, and this is why we need protection of safety data and information. How does it work in Annex 19? So what do we protect? We protect safety data and safety information, and states shall, through national laws, regulation and policies, protecting safety data, safety information, and related sources, ensure that a balance is struck between the need for the protection of safety data, safety information, and related sources, and the need for the proper administration of justice. That safety data and information and related sources are protected in accordance with Appendix 3 to Annex 19. The condition under which safety data, safety information, and related sources qualify for protection are specified, and safety data and safety information remain available for the purpose of maintaining or even improving aviation safety. So again, it is essential to ensure the continued availability of this data, but at the same time, while allowing the proper administration of justice. So states shall ensure, that's what Annex 19 says, that safety data or safety information is not used for disciplinary civil, administrative, and criminal proceedings against employees, operation personnel, or organization, disclosed to the public, or any purpose other than maintaining or improving safety. Okay, this is principle of protection, and of course you get the unless the principle of exception applies to find the proper balance, and the principle of exceptions are listed again in Annex 19. So the protection shall only be granted when the competent authority, again, that is not necessarily the same as before, determines that there are facts and circumstances reasonably indicating that the occurrence may have been caused, okay, by acts constituting gross negligence, willful misconduct, or criminal activity. And also a little b, if after reviewing the safety data, the competent authority determines that its release is necessary for the proper administration of justice, and that the benefits of its release outweigh the adverse domestic and international impact such release is likely to have on future collection and availability of safety data and information. And little Charlie, you'll see, is about reviewing, determine that its release is necessary for maintaining or improving safety, and again, its release outweighs the adverse domestic and international impact. Okay, so these are the three principles of exception to lift the protection of safety data in Annex 19. So in that case, we do talk about incidents or events which are not accidents. This is where the principle of Annex 19 do apply. If you don't want to read the long text I just read, there is the same explanation, but in graphical format, in like a decision tree, with the same 3A, Alpha, Bravo, and Charlie exceptions that you need to consider to lift or not the protection for safety data or information and related sources. Everything is in Annex 3 to Annex 19. So to sum it up and wrap up, I would like to share with you this, to give a global picture of the hierarchy of protection and what principles of protection to apply in which case. So imagine there is a CVR or airborne image recorder or any other records listed in Annex 13, paragraph 5.12. The first question to ask yourself is, are they being used for an aircraft accident or incident investigation? If this is the case, then the principles described in Annex 13 prevail and take precedence over any principles in Annex 19. If it's not the case, if it's not the subject of accident investigation, then are they being used for safety management purposes? If this is the case, then apply the principle listed in Annex 19. And I didn't talk about it, but if it's no to that second question, there are other provisions in another annex, Annex 6, related to routine operations, in particular maintenance operations of flight recorders. Okay, so this gives a hierarchy of the protection depending, basically, if you have an accident investigation, Annex 13, otherwise Annex 19, and otherwise Annex 6 for routine operation. I am now open for questions, not without saying that you of course have more information in the different ICAO documents and annexes in both Annex 13 and Annex 19, and also in the Safety Management Manual, the document 9859. And that's my presentation. Thank you for your attention.
Thank you, Arnaud. Thank you very much for your interesting presentation. Usually, I found in the ICAO legislation something very interesting because usually, since the beginning in 1994, it foresees future issues for the aviation. We have a question about protection of safety related information, about the dilemma between persons wanting to improve safety while doing a self-incrimination. Accordingly, due to this question, this prevents very much to be honest in interviews when knowing that the files might go to the administration of justice, even if after a balance check. So do you have any recommendation, your point of view on this aspect, on this dilemma and protection of safety information?
Not really. I can only repeat what I tried to convey during this presentation. So we talk about criminalization here. So I can assume we probably would be talking about at least injury, if not fatalities. And therefore, in that case, an Annex 13 investigation would be going on, and the protection of investigation records are described and should be applied by states by having the proper regulation in place, the proper policy, the proper rules, so that the principle of protection listed in Annex 13 should apply.
Okay, thank you. Another question about the Annex 6. Is there any provision of this annex against the disclosure of information contained in CVR or IR during routine maintenance operations?
So if we're talking about Annex 6, protection, it means that we went through all the other questions that I talked about earlier. So that means there's no active investigation, and it's not for safety management purposes, and therefore the provision in Annex 6 say that it should not be used for approaching blame or liability. So it should not be used if you go down to the provision of Annex 6. This is really for routine operation, like I said, mainly for maintenance, controlling the signal quality and so on.
Yes. Okay, perfect. Thank you very much. I think we are at the end of this day 3 of this fantastic webinar. And I don't know if we have time for, yes, another question about, well, I just read the question. What is the procedure from ICAO when contracting states file a difference to ICAO Annex 13 with the reason of not being compliant due to the National Criminal Authority overruling this? So if, for example, the ICAO get in contact with the Department of Justice or other institutions when there is this different approach for ICAO member states due to the National Criminal Authority overruling.
Okay, so then the question is about, if I understood it correctly, about filing differences against some of the provisions of Annex 13, which is of course of course, possible, and especially the provisions that we talked about, but maybe about bringing protection to accident investigation records.
Okay.
In that case, this is a state responsibility to show to the world by filing differences that it's not compliant with this standard or recommended practice.
Okay, perfect. I think we are at the end of this day 3. Once again, thank you very much on behalf of every institutions and stakeholders that have organized this webinar. I would like to remind you the 4th day of the Just Culture and Judiciary webinar. It will be on 17 November, 2 o'clock until 4 o'clock, and the theme will be on healthcare, in the healthcare industry, how Just Culture works. And I think it's during this time of COVID-19, so it will be very, very interesting to explore also the theme of the Just Culture in the healthcare. So thank you very much to everybody, and see you on the 4th day on 17 November. Thank you very much again, and have a good evening.
Goodbye.
Goodbye. Thank you very much.
Thank you.